This video is made possible by Practical Defense Systems, the best online security training at the lowest prices. You can start your security career today online at pdsclasses.com. Check them out. Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. I really deeply appreciate everything that you do. You may want to check us out on these alternative video locations, by the way, because YouTube is always kind of iffy, and you never know whether GunGuyTV is going to be around in the next 10 seconds or so. So check us out at these other places and subscribe to at least one, and that way if something happens to us, you'll know where we went. Likewise, you might check out the GunGuyTV audio podcast. It's a firearms podcast that appears twice a month, and you will find it on your favorite podcast player. Now, today I want to talk about the SCOTUS decision to actually take a Second Amendment case. Wait, what? We've been trying to get them to do that for over 10 years, and now they have. Well, I don't really know what I'm talking about when we get into the weeds like this, but Chuck Michel does. And so Chuck is going to join me on the show in just a minute. Chuck Michel, in case you don't know, is a senior partner at Michel and Associates. He has been a litigator for a long time and has litigated a lot of Second Amendment cases. He's a civil rights advocate, a Second Amendment advocate, and he is also the volunteer president of the California Rifle and Pistol Association, and genuinely a great guy. But don't tell him I said that. I don't want him to get a fat head. I'm also joined by Stephen Halbrook, and just to let you know a little bit about Stephen, I actually pulled up his website. This guy's very, very impressive. He's going to join me in a minute, and hopefully I don't give him a fat head either. But Stephen is a senior fellow of the Independent Institute. He has taught legal and political philosophy at George Mason University, Howard University, and Tuskegee Institute. He received his Juris Doctorate from the Georgetown University Law Center and PhD in social philosophy from Florida State University. He's also the winner of three cases before the United States Supreme Court, and he's also testified in Congress and Senate and so on. So the minute you see him, you're going to go, oh, I know that guy. He's going to join us as well, and I'm going to let them talk about what they think the merits of this case are, what they think the future brings, and how encouraged they are by the fact that the Second Amendment is now being litigated again in the halls of the Supreme Court. So without further ado, let's get to that interview. Well, Steve and Chuck, thank you very much for joining me. You guys obviously know what you're talking about. I obviously don't. And so that's why you're here, because people would love to hear what your thoughts are on a few things, not least of which is this case that SCOTUS has elected to take. Finally, what are your thoughts? Are we in a good position, bad position? Why?
Look, my name is Stephen Halbrook. You can look at my website, stephenhalbrook.com. And just by coincidence, my new book, The Right to Bear Arms, A Constitutional Right of the People or a Privilege of the Ruling Class, came out on Amazon on Monday. And on Tuesday, the Supreme Court accepted cert, decided to review the case in New York State Rifle and Pistol Association versus Corlett. And that is exactly the subject of my new book, The Right to Carry Outside the Home. In other words, there are 8 states nationwide, New York, California, the other usual suspects, that don't have carry permits available to law-abiding citizens in general. 42 states do allow law-abiding citizens either to carry without a permit or to carry with a permit. And so the Supreme Court's going to decide the issue. It's an incredibly important case. The right to bear arms is part of the Second Amendment. And we have states, or rather we have courts upholding these state bans on carrying in total disregard of the explicit words of the Second Amendment, the right of the people to keep and bear arms. To bear arms doesn't mean just to take your gun from your kitchen to your bedroom. It means to carry in public. And there's no reason why law-abiding citizens in general cannot exercise that right. They do in 42 states. And so we expect the court to resolve the issue as to New York law, but I think a lot of our listeners are in California, and if the court does the right thing, then Californians are going to get the same Second Amendment rights recognized.
What are your thoughts as to the odds, Chuck? What do you think?
Well, first, let me say I'm Chuck Michel. I'm the president of the California Rifle and Pistol Association. Stephen and I have both been litigating Second Amendment cases, either alone or together, for decades now. And we were both at the Heller and McDonald Supreme Court arguments and expected good things to come from those. Didn't expect we'd have to wait 11 years. Which is what's wound up happening. Everybody knew after the Heller decision that the next question was going to be whether or not the Second Amendment is incorporated through the 14th to apply to limit state and local governments from infringing on your right to keep and bear arms. And then after McDonald came down, everybody knew the next question was going to be what standard, what level of scrutiny, what test is the court going to apply when judging the constitutionality of a Supreme Court case. So Stephen and I work together now on the Second Amendment Law Center, which is a recently launched 501c3 that will be doing things like coordinating amicus campaigns, has been filing some amicus briefs in the Supreme Court on some other cases, gun cases, and we'll be working very hard to get a win along with the other parties and friends of the court in this New York State case. But we're fortunate that the court, people have been trying to get a case, whether it's a carry case, a public carry case, or another type of Second Amendment case, back to the Supreme Court every day since 2010 when McDonald came down, and the court has just not taken any of those cases up until now. They took one case out of New York, which the state and city of New York then repealed their law to moot the case and make it so the Supreme Court couldn't rule on it. And they were successful in that. So, and that's been something that a lot of jurisdictions have been willing to do. They'll withdraw their laws, repeal their laws, or settle for a loss rather than go to the Supreme Court because they're afraid of that national precedent that we might get from a Supreme Court ruling. Now that we have Justice Kennedy is gone, and we have Justice Barrett now in there. Even if Roberts is, depending on what side of the bed he wakes up on that day, we still should have a 5-judge majority. We know we've got a couple of very, very strong Second Amendment supporters in Thomas, probably Alito, Gorsuch, and Kavanaugh. Right. So we should have more than enough votes now to get a 5-4 or a 6-3 majority. But the question is going to be, how much teeth are they going to put back into the Second Amendment? Because since 2010, most courts have really bent over intellectually backwards to try and let the government justify any law on the flimsiest of evidence. They really just haven't held the government to its burden of proving that before they infringe on your Second Amendment rights, they've got some kind of a justification that the law is really going to work, and it doesn't unnecessarily restrict your right to keep or bear arms.
How broad do you think that they'll make this? Are they going to do another narrow one that leaves all kinds of opportunities for lower courts to mess around with it, or are they going to be a little broader, particularly in the area of scrutiny?
Right. Look, it's not going to be a revolution, but it's going to be very significant potentially. Let me say a little bit about how the courts, ever since Heller and McDonald were decided, have tried to nullify the Supreme Court decisions in those cases. We start on the right to carry. Let's talk about that specifically. Probably the first court that said something about it was the High Court of the state of Maryland. And Heller said explicitly that bear arms means to carry in case of confrontation, and it means to carry a gun, such as in the pocket or on the person. And the Maryland court said, oh, well, if the Supreme Court really meant that, then they're going to have to be more explicit. And so then you have the Federal Circuit for the Fourth Circuit Court of Appeals repeat that quote. And so every time they want to uphold a ban on carry, they basically nullify what the Supreme Court said. They ignored the text of the Second Amendment, the right to bear arms. And what they've been doing the most lately, like this, I'm talking about the Ninth Circuit, it decided Young versus the state of Hawaii. State of Hawaii, you can only get a carry permit if you're a security guard on duty, and you can only carry openly. And so the Ninth Circuit goes through this entire analysis, ignoring the text of the Second Amendment and digging up old English monarchical statutes in an attempt to say, well, this is the tradition, the English heritage that these monarchs, who the Americans had a revolution against, they had strict gun laws. And it traces back to the Statute of Northampton of 1328. And that supersedes the Second Amendment, they say, virtually. And so you have this incredible false narrative, historical narrative, piped up by these courts who are in rebellion against the Supreme Court decisions. And let me just mention the latest case the Supreme Court tried to decide that Chuck mentioned, the New York City ban on carrying a gun outside of your home. You can't get a carry permit in New York City, but you can get a premises permit if you pay a whole lot of money. You couldn't take it outside of your home. And they said, oh, it would be such a public safety risk. It's like if you took it in your car trunk unloaded to like a shooting range in upstate New York, that you might go berserk and get road rage and kill people and all of this stuff. And then once the case got to the Supreme Court, all that public safety rationale just melted away. It wasn't really so dramatic after all. So, but what the court now can do, I think chances are good that it'll simply construe the text, history, and tradition of the Second Amendment, the exact language. It doesn't really need to set a standard of review. If they ban ordinary law-abiding people from bearing arms, you don't need to decide if it's strict scrutiny or intermediate scrutiny or less than intermediate or whatever else. You just look at the language of the amendment and say, look, that's it. And so all gun laws are not going to fall from this. There's no other area of the law that's going to be affected other than right to carry, although the court probably will give some guidance that would be useful in how you evaluate other gun restrictions. So there's been more courts. I think there's been an awakening of some courts, at least on this issue. The district court and one of the district courts in California just invalidated a portion of the law that requires 3 handguns to come off the roster for every one that's put on there. And there's, the magazine ban has been invalidated, although the Ninth Circuit in Bonk is going to rehear it, and there's probably an automatic reversal of that great panel decision in store for us. But look, we've come a long way, and I think we're going to keep going. And the anti-gun people are trembling in fear. If you look at, there was an article in Time magazine today. I mentioned my new book, by the way, but it quotes the new, or rather the anti-gun lobbies being so emphatically afraid because now the Supreme Court is going to hear this case. It's like the sky is going to fall. I think they read the handwriting on the wall, like I think we do as well, and they're in for a big defeat.
Yeah, this is why Stephen's book is really, I think, like there's some kind of divine intervention going on here, because the book came out at just the right time. And what's happened is, Steve talked about standardized review. Conventionally, when you get into like a First Amendment case, the court applies some kind of standard of review to determine whether a law that restricts speech is constitutional or not. And so there's a higher standard if it's like a political speech where you're advocating for some candidate, versus like you're trying to advertise for laundry detergent. That speech is less protected. So there's all these sometimes rather complicated analytics that get applied depending on what the right is that you're protecting and how far the law goes to restrict that right. And one of the things that Scalia, God rest his soul, and Roberts were laughing about on the bench when they were listening to the Heller oral arguments, they were saying, why, if we're starting fresh with establishing the Second Amendment as a fundamental right, why would we adopt this complicated infrastructure, Byzantine standard of review analysis that has evolved over the years for First Amendment jurisprudence? Why would we impose that on the Second Amendment. And everybody pretty much agreed. Then you got the opinion, and in the opinion, the liberal side of the court was advocating for very low standards so that almost everything remains constitutional. Scalia specifically said, no, that's not what it's going to be, but never clarified exactly what it should be. And so there's been this evolution since Heller came down of a standard of review that is very deferential to government findings, that is very easy to meet for the government to prove that a law should not be struck down. And they find things outside the scope of the right by misapplying the Heller argument, because the Heller dealt with guns in your home, not guns out in public. So they say, well, the Second Amendment doesn't even include guns in public because that wasn't part of Heller. Well, yeah, no, it wasn't part of Heller because that's what the specific law that was at issue in Heller was about, was the gun in your house. But they didn't have to address carry or bear, I should say. They addressed it keep in that particular case, but they clearly said the Second Amendment is an individual right. So now this debate has gone on, and what they're moving towards is text, history, and tradition, the originalism test.
What exactly do you mean when you talk about a standard of review, and what is the problem with that currently? And what do you mean by examining text, history, and tradition? How does that change what's happening in the court now?
You want to take that, Steve?
The nice thing about text is that just means the words of the Second Amendment. The right of
means what it says.
Yeah, the right of the people to keep and bear arms shall not be infringed. And if I can turn the clock back to the founders, they wrote that so people like you and me, all the listeners, can read that and understand what it means. And in fact, it's not just for the government people to read. It was written against them. It's telling them you can't infringe on this right. And it's written in a simple language. And we had the idiocy of a lot of courts before Heller tried to say, well, it doesn't mean that at all. It doesn't mean the people. It means the National Guard or the militia. It doesn't mean keep and bear. It doesn't mean arms. Handguns can be banned. So this is the easiest part of this to understand is the text. And when we say history and tradition, what we mean, for example, is turning the clock back to the founding. What laws were on the books at that time about gun ownership and carrying guns? Well, I can tell you, peaceably carrying a gun, that was not unlawful for anyone. So that was considered the mark of a free man. It was the mark of a slave that law, that right was not respected. In fact, that's what the slave codes provided for. But when we look at history and tradition, all we're looking at is American history and tradition. And do we have a long tradition, for example, of banning guns? No, we don't.
Essentially, what you're saying is what the words meant when they wrote them.
Exactly.
Right.
And what their intentions were when they wrote them is how they should be applied today. It's not a living document that changes and gets morphed around as they want to make societal changes, but it is what it is, and it is what it was, and we should look at it in the same way today. Is that essentially what you're saying?
Yes, and don't get bogged down in all this analysis of the scope of the right and interest balancing tests and what's the government's interest, what's the individual interest. You just look at what the founders were trying to do. That's why Steve's book right now, because we're going, I think everyone understands, we're going to shift away from this interest balancing test that has been applied in the courts since McDonald to this text, history, and tradition, which is conventionally known as originalism, the originalism approach. And Steve's book lays all that out. They know it, and they're doing everything they can to undo it. They're cranking out the false history, trying to water down what the founders meant when they wrote this. Steve can tell you more about that, but Bloomberg saw this coming and has already financed a lot of historical stuff to try and undo it.
Let's just prognosticate here a little bit. Let's say that we get a favorable ruling, however you might define that. What effect does that ruling have on a practical basis where the infringements in states like California, New York, and so on are concerned? Does it start a domino effect on these other things? And if so, why?
Well, if the court makes a clear holding, like we expect they will, that you have to make carry permits available to law-abiding people generally. All those, there's 8 states that don't have that, that have discretionary issuance. They're going to have to revise their laws, and what they are going to have to do. A lot of their laws can stay on the books. Like, do you have a criminal record? Have you ever had a mental commitment? Things like that. You're not going to get a permit, and you will have to have training in most cases. But if it says you have to have some special need that normal people don't have, or something where you don't qualify unless the police approve you, that's going to have to be stricken from the state laws of all 8 of those states that have those kinds of laws.
What is it about this particular case that has you so encouraged and optimistic?
A lot of that has to do with the split of opinion. The fact that they took it, Justice Thomas's previous dissents when they declined to take it, it all signals kind of where things are going and what the judges are inclined to do. That's why I'm optimistic. That and Barrett being the most recent appointee, it's just a numbers game. But I think that the dissents have in previous cases where the Supreme Court, remember, it takes 4 votes to take a case to the Supreme Court, 5 votes to win it. In previous cases that have been submitted to the Supreme Court and asked for review and they've turned it down, judges have dissented and said, we should have taken that case. So we've gotten a preview of what a lot of these judges are thinking from their dissents in previous denials of petitions for cert. So that's what makes me hopeful. I kind of know what they're thinking already. We don't know exactly what Kavanaugh or Barrett are thinking, but we've seen their previous opinions in other rulings when they weren't on the Supreme Court that make us hopeful.
But if you look at the justices who are there now, let's start with Amy Coney Barrett. She was a 7th Circuit Court of Appeals judge, and she wrote a very lengthy opinion based on text, history, and tradition, a dissenting opinion where she said, well, you can't really just ban all felons from having guns. You can only ban violent felons from having guns. And there was another case that they didn't pay much attention to, but it was a search and seizure case where she said that you have a right to bear arms and the police can't just do a search and seizure because they know you have a gun if you haven't done anything wrong. So she's on record. Justice Thomas has many times filed dissenting opinions, dissents from denial of cert, advocating the right to bear arms. I think the Peruta case was one. Justice Scalia joined with him. Justice Gorsuch, I think, in a later case, made clear his opinion. Justice Kavanaugh. I did a case in the DC Circuit called Heller 2, and he did a dissent in that case, and he said the firearm registration system was against the Second Amendment, and also the ban on so-called assault weapons. And so I think, and Alito, I mean, he wrote the opinion in McDonald. He's a very strong Second Amendment advocate. And so I think we have 5 votes there, and I think I'm very comfortable with those justices. And I think Roberts might come around. I mean, he joined with the majority in both Heller and McDonald, and he was the one who asked the great question that I think Chuck was alluding to a minute ago in oral argument in the Heller case, like, why are we trying to decide whether there's a right to bear arms that can't be infringed when that's what it says, and we don't have to have all these stupid standards of review that we made up.
You can get a home run when you're up to bat if the right batter is up. Who's batting this thing for us? Is it Paul Clement? Is it somebody else? Who's up there? And do we have a good team fighting on our side?
Clement and Kirkland and Ellis, and they are very good for this particular case. They're Clement is very well respected. You can't. Steve's argued a couple cases in front of the United States Supreme Court. I'm too old. I wouldn't do it. It takes all your time for months before the argument. I would have to shut down my practice, and Steve did basically that when he prepared. But Paul is known as an advocate as opposed to an activist. Depending on the lawyer that you have, judges listen more or less carefully to what the lawyer is saying, and he is the kind of lawyer, former Solicitor General for the United States, former Attorney General for a little while for the United States. He has a lot of credibility with the court, so they will be paying very close attention to what he says. And he's been in front of them, I think 50 times, more than 50 times.
He argued a case just a few days ago on all kind. He argues on all kinds of issues.
Yeah.
And he's been a very strong advocate on this issue. He's very well respected by the court, like Chuck said. His team will write a first-rate brief, and there'll be a ton of amicus briefs on both sides coming in. The court's going to be well informed, and all the arguments are going to be there. The clerks are going to have more than their work cut out for them. It's going to be a major case. I expect it probably won't be, an opinion probably won't come down until June of 2022.
Yeah.
It'll be argued in the fall, but then the most controversial decisions come down at the very end of the term. So we'll have to wait a little while for that. But Joel, I like your analogy about you got to get up to bat if you're going to actually hit the ball. And I think we're up to bat here. I think the other side is really running scared, and there's really nothing they can do like they did in this New York City case last term. They mooted it out by they saying, well, if you get a permit to have the gun in the city where you're going to your second home, then we'll let you take it there. So they amended the law just in the most stingy ways. But then that was enough justices said, okay, this case is moot. But what are these states going to do to moot this case, New York specifically? It would have to change the law to shall issue.
Right.
There's no other solution. As long as they keep with what they've got now, there's no way they can make it go away.
The problem is that getting that license has been treated as a privilege rather than a right.
That's right.
It's one of the things that makes this case, I think, a little more palatable for the Supreme Court. They're just interpreting, what does bear mean? The Second Amendment, bear arms means carry, not just keep in your house. So that's not particularly controversial. And they've got the benefit of 40 states that already, or 42, I think it is, that have gone shall issue, where they already know it's not like the doomsday prognostications that are predicted by the gun ban lobby of blood in the streets and Wild West shootouts. None of that has happened in all the states that are already shall issue, or for that matter, constitutional carry. So they don't have to worry about that kind of political fallout because it's already pretty much the norm. But once it becomes the norm, once gun possession in public is normalized in California, it just like the ownership numbers going up have changed people's opinions. People are less afraid, the people who don't own guns, who don't understand guns, those folks get sort of used to it. And so it's not as easy for the politicians to scare them into passing some law that serves no purpose but gets the politician a good press conference.
I do have another question for you. That is, you talked about the fact that the lower courts just have been very disobedient when it comes. I'm going to call it what it is. They've been very disobedient when it comes to the Supreme Court's decision in Heller, and it bears the question of what does the Supreme Court have to do in this decision, or any decision for that matter, to compel the lower courts to obey them.
It's got to be directly on point and like straight up in the face, like we mean it and this applies to you, because the Supreme Court already said in the Heller case, the right to keep and bear arms means to carry. It means to carry in case of confrontation, for self-defense, things like that. And then the lower courts, they go through this analysis and they say, well, if they even mention what the Supreme Court said, but then they go into their test, like we have to go beyond that. And is it in the scope of the right? And is there a balancing that we want to do so we can balance the right away? And then hocus pocus, they use all this fancy judicial terminology, things that they made up. And they say, whoa, no, you don't have a right to bear arms after all. That only applies to people sanctioned by the government. So it's like a fraud on the court, if I can use that term. It's equivalent to the way they used to say. They used to argue that, well, nobody has a right to bear arms. That's only the militia that has a right to bear arms. And so Supreme Court slapped them around, said, nah, forget that. That's not right. And the Supreme Court's just going to have to tell them straight out, like, look, this means you, it applies to you, and your law is invalid and you got to change it.
Yeah, it really is a matter of creative interpretation and trying to misread deliberately, I think, in many cases.
Yeah, I agree with you.
The court said in Heller, because they don't like that. And unfortunately, I don't think I think it's a safe bet. It's not a sure thing, but it's a safe bet that the court is going to strike down these special need requirements to get a public carry permit. And because they'll say, and they've already narrowed the question, they rewrote the question presented in this case to make it more specific about the Second Amendment as it applies to public carry. That's not going to. They will say, yes, the founders intended for people to be able to carry firearms in public, but they're not. That's not going to help us win or continue to win cases like the Duncan case in California, where we're challenging the ban on the possession of magazines that hold over 10 rounds, or the Rhodey case, where we're challenging the background check requirement and all the fees imposed to buy ammunition, or the new taxes and the new fees, which are really poll taxes essentially on buying guns or ammunition that are being imposed across the country. The Supreme Court, I think, is going to be very careful to not get too broad in its ruling, to not give us too much language that you can use in other cases to strike down other types of laws. But they will, I think, say that all this interest balancing baloney that's been going on is not what's supposed to be happening. And what that results in is a hard reset. Even if we've challenged a case and lost because they applied some kind of interest balancing test rather than the originalism approach, that you can go back and relitigate that. And then Steve's going to have to write a lot more books on a lot more different topics. Get me one on magazines, will you?
Yeah.
Because
I'll buy it.
Because there's going to be a lot of history debated and a lot of legislative, founder intent argued when it comes to judging the constitutionality of other types of gun control laws.
We can't quit. If you're watching this decision is awesome if it comes out our way. The fact that they're taking the court case is we're up to bat. I mean, it could be it could get us to first base. We could hit a triple. We could knock it out. We could hit a home run. I don't know, but hopefully it'll be positive, move the ball forward, but we can't quit. We can't relax. We can't, because the other side, as Stephen just said, is not going to quit and they are not going to relax. And with that in mind, I'd like to see if we could transition the discussion to something you mentioned at the outset, Chuck, and that is some Second Amendment Law Center or something that you guys are putting together. What exactly is that, and what are you doing? How can we support it?
Well, the Second Amendment law, Steve and I, as I mentioned, we've been doing this for, I hate to say it, but decades. We know everybody who's been litigating these cases in all shapes and forms forever, and we pulled them all together to join the legal team of the Second Amendment Law Center. It's a 501c3, so donations are tax deductible if you qualify, because we recognize that there's going to be a need for a lot more lawsuits once we get this, assuming we get this, and even if we don't, there'll be more lawsuits that need to be brought to challenge a lot of other laws that have no real solid justification, that are designed to try and advance an anti-gun and anti-gun owner agenda, part of the cancel culture, part of the war on the gun culture, because there are certain segments of the progressive society who don't want individuals to have firearms. So there's going to need to be a lot more litigation, and this becomes basically a litigation and information clearinghouse and a force de jure in its own right that can file these kinds of lawsuits, support well-chosen lawsuits, strategically wise lawsuits in other jurisdictions, and do the lift for what needs to be done now, but especially after we get what we hope we're going to get from the Supreme Court. So Second Amendment Law Center is online, 2alc.org. There's a Second Amendment Law Center Facebook page. Subscribe and you'll get, we're just getting the resources section off the ground, but we've already filed a brief in the Supreme Court in the Caniglia case, which Steve wrote, which is about whether or not you need a search warrant to seize somebody's firearms. And we'll be doing a lot more than that. We have the A team of Second Amendment lawyers from all across the country, the guys who have the experience and the skill sets. So as long as we have the resources, we will keep filing those lawsuits. Unfortunately, the other groups out there, even the NRA, I mean, it's facing financial difficulties now. It's going to take a lot of resources, money, funding.
Yeah, money.
And our lawyers give us, we're all working for reduced rates because we're true believers. But it's still, you don't
believe that. You should see the Yugo that Chuck drives.
That's right. Hey, I got a discount on my Hummer.
No, I get it.
It's down for some reason for those big ones. No,
nature, you know what, bro? Nature abhors a vacuum. And as other groups, NRA, for example, are struggling, other folks are picking up the baton. And it seems like that's what you're doing with this. You're grabbing a piece of that and running with it. And I applaud you. I give you a round of applause.
If you're watching in California, don't forget the CRPA Foundation. We've got some great wins. I mentioned Duncan and Rhodey. Those are fantastic wins. We were going to try and hold on to those in the Ninth Circuit and maybe take those to the Supreme Court. But the Second Amendment Law Center and CRPA Foundation and other nonprofits are working closely together, coordinate our efforts and get the most best results that we can. And we have the team in place to do that.
Guys, thank you very much for being on the show. And I really do appreciate it, Chuck. It's always a joy. Steve, it was very nice to meet you, not, in person, but I hope we get to do that at some point too. And I'm very grateful that you came on the show. Thank you.
Oh, thanks for all you do. Joel. My pleasure.
Thanks for helping getting the word out, Joel.
Thank you very much, again, for all of your support, and thank you for listening through the entire interview. You are truly a Second Amendment supporter. By the way, I will put the links in the description for Stephen's book, as well as the book that you should have if you're in the state of California, that helps you know what the California laws are. That one is actually written by Chuck. And we'll also put the link in there for Steve's website, the California Rifle and Pistol Association, which you should definitely join. I myself am a life member. And also, I'll put in there the Facebook page for the new Second Amendment Law Center. Check all of those things out, too. Thank you again for all of your support. Keep the fight going, because we can never, ever quit. We've got to keep fighting for our rights. That's the only way we're going to keep them. In the meantime, wherever you go, whatever you do, stay safe.